Okay, today is Sunday, September 30th, 2012. This recording's for Workman's Comp, and here we go.
Okay, this is Julio Zamora. Today is Saturday, September 29, 2012. I have a notation I want to put here that I filed a request for dispute resolution before the Administrative Director, DWC AD 10133.55. Okay, case number 25009-25228. Case number ADJ 727-7670, ADJ 688-1044, ADJ 836-1199, ADJ 729-6751. I'd also like to note that I made a notice of application, date of service 6/1/2012. EAMS case NBR number is ADJ 836-1199. Date of claim of injury was 12/7/2009. And I made that claim, like I said, on 12. The date claim injury was 12/7/2009. Actually, the injury was before that, but the claim was filed on 12/7/2009. The date of service was 6/1/2012. Okay? And this was an application for ADJUDICATION of claim. Had been filed with the Workers' Compensation Appeals Board for the above claim injury. Please reference the above EAMS case number on all correspondence to the WCAB. This notice constitutes a conformed copy of the application. Date application filed was 5/31/2012. Okay, so that was sent to the Division of Workers' Compensation Appeals Board. So I want everybody to realize that, and that's going to be for the court. And I also like to know that on 12/7/2010, they took my lifetime medical insurance away from my family and myself. They just stripped me of it all. If you have any idea how much money that is, that's a lot of money. A lot of money. Just because I received an offer of work on 12/1/2010, they stripped me of everything. And I had an active FMLA, which I should have been able to obtain medication, but I was not allowed because they stripped me of everything. Okay? And I'd like to make that for the record, and that's going to be part of my statement for the court on October 31st, 2012, because they refused me to have a treating physician. And this is the second notice, but actually it's the third notice. But it's my second notice request for a change in treating physician. Okay, this is Julio Zamora, trying to make a recording for the court for Workman's Comp. Today is September 27, 2012. I'm going to start off with this offer of work that I received on December 1st. Went to work on December 3rd and was sent home on December 7th, 2010. On your offer of work, it stipulates the employee must accept, reject, or object to this offer for regular work and return this form to the employer or claims adjuster listed on the form within 20 calendar days of receipt of the offer, or it will be deemed that the employee accepted the offer and has waived the right to object to the location or shift. Okay, and this was, I received this on 12/1/2010, and like I said, I went to work on December 3rd. On December 7th, 2010, I was sent home. And I should also like to note on this notice of offer of work, it's on notice of offer of regular work for injuries occurring on or after 1105, form number DWC AD 10118. Okay, and this one was completed by the claims adjuster, Mr. Ria Espinosa. Okay, and it started, it was 10/13/2010. position provides wages and compensation of $1,006.56 weekly wages. There are equivalent to or more than the wages and compensation that will be paid to you at the time of your injury, or was paid to you at the time of your injury. This position is expected to last for a total of at least 12 months of work. If this position does not last for a total of 12 months of work, you may be entitled to an increase in your permanent disability benefit payment. Okay, and that's what it says. Those of offer work, so I should be working. It shouldn't have sent me home on December 7th. Because I didn't have 20 days to decide anything. It's bad from the 1st to the 7th. It's only 7 days, and I was on FMLA, and he just sent me home. And they threw me a ball on medical benefits and treatment and medication, drugs, whatever. I also have lifetime medical, which I lost. Okay, and I also like to know that I took a physical DOT examination on 10/1/2009, and that expired on 2011. And that in 2009, I took a DO test with Dr. Yes and the company doctor. Later 2009, the company doctor took a DOT examination. On the back it says I need hearing aids. It says wearing hearing aids. So I need hearing aids. They need to accommodate me because I filed a claim on 4/13/2009. So they knew that I have a hearing problem. And the dispatcher knew it also. So that being said, I went to the doctor for my hearing on 10/10/2011. And I found out that I had a hearing problem. Because they didn't send me to a hearing doctor or anything else. They just completely ignored the issue. And they're still ignoring the issue. It's not being brought up. But I presented a document in the last hearing at Workman's Comp, severe profound hearing impairment. And then also, I mentioned the fact that I needed accommodation needed for trial, including special hearing aids. And I also added in that they need to be purchased at Kathy Tower Center for Better Hearing, 1801 Colorado Avenue, Suite 150 in Turlock, California. Phone number 209-216-3300. Or by the court, as you will know. I said, please reply by December 5th, 2011, if there are any problems. So, nothing happened. They just completely ignored it. And the doctor said I had a severe profound hearing impairment, and it's been ongoing. So, that's the thing with the hearing aids. And I have a prescription and everything. I'm also going to turn in an MRI for my lumbar and spinal thing that I had when I was in the hospital. I went to Lexington Hospital on 4/5/2009. I was out of the hospital the next day at 4/6/2009. I seen Dr. Hubby and I gave her a copy of the referral or the MRI saying I need to go to Dr. Baby and ask because I have a pinched nerve, a little bad. According to the hospital report. Safeway denied this, stating that Nancy Perdillo stated that it was a sprain because I didn't see a doctor or had x-rays or anything else on 3/21/2009 when I see Nancy Perdillo. Of course, I had a follow-up with Dr. Huggy on the 22nd. She left my leg and sent me home. I had nothing. So, anyway, I'm going to give him the doctor's report. It says, Doctor first report of occupational injury from Los Angeles Memorial Hospital. And it says that I went in there for that day thing, the same day on 3/21/2009. It's typed in this form. And then they adjust the findings below. Low back pain, radiology, MRI. So I'm turning in the MRI with that statement. And I'm also turning in the 4/13/2009 for my hearing impairment. Okay, so we have those issues, and I'm turning in the National Letter of Health. Attention Robert Nicewarm, because he knew that I had an FMLA and it was active on December 7, 2010. I also like to point out that I was denied 2 appointments, cancellation appointment notes. I'm going to hand in one of them from Safeway Journey Workers' Compensation for Lapo, Joseph Lapo, okay? And also telling you the envelope showing that I received this document on 12/1, the offer of work. And I'm also going to carry in that agreement was filed by Safeway or reference discharge on December 16th, but it was received December 17, 2010, General Census Local 439. And on the left-hand side, it says Local 439 via fax mail. Safeway fax this document. Down below it says Employee, DC Director, Labor Relations. No one was informed. This letter was between Mr. Nicewanger and Mike Sadler and no one else. I did not receive a copy of this letter, reference discharge. And it says I was discharged on December 6, 2010, and I went to work on December 7, 2010. This letter is dated December 16th, going back to December 6th. Okay? Now, Mr. Nicewanger responded on December 7, 2010 that in accordance with Article 25, 26 and all articles of the CBA, consider this informal grievance protest and the unjust improper without just cause discipline issued to Mr. Zamora in a letter dated December 16, 2010 in violation of Article 25 and all other applicable articles of the CBA, etc. There's no doubt that they violated all those articles, and I'm going to state the reason why. They did not complete step 1, null and void. They did not complete step 2, final and binding. Did not file a written agreements within 10 days. Did not send registered mail and was never informed. Okay? So that's the reason the discharge was denied. It violated all articles of the contract. Okay? And down below it says the working union will grant the discipline be denied agreement to be returned to work immediately and agreement to be compensated for all lost time and benefits. Please provide a date and time to instruct agreements in accordance with Article 26 grievance procedure. Now I'm going to read one more paragraph because it's very important and it makes you know this. Additionally, provide any and all supporting document, notes, strip sheet, videos, and statements surrounding the investigation and discipline issued to Mr. Zamora that the company relied upon as soon as possible, but no later than December 25th business on 2010. It didn't happen. They didn't submit anything, nothing, not one piece of paper that I'm aware of. And I called Nicewanger, I think on the 16th, and I also called him before Christmas, and nothing was handed in. In fact, they set a meeting for January 11, 2011 at Safeway, Tracy, California, 1-800-388-2125. And this was emailed to James Williams, Transportation Manager. And it says here via email, James Williams, 18@Safeway.com. And I should also note that this was sent by Robert Nicewanger, business representative to Ben Pelosi, Carl Romero, Safeway Labor Relations, Ed Smithman, Mike Sadler, and Julio Zamora. This was mailed. It wasn't registered mail, and I was informed by the union and not by the company. Not by the company. They're required to send me registered mail. They didn't do so. On top of that, they didn't prove anything on December 25th. And on top of that, they didn't respond within 10 days to set up a meeting or anything else. And why they continued on, I don't know, when discharge was denied. And that's about the extent of it. The discharge was denied. They didn't respond in 10 days. They didn't respond in 20 days. They didn't respond in 30 days. In fact, they didn't respond at all. I had a meeting that because the discharge has been denied. Okay, the last important document is that I filed a 132A. Okay, I filed a 132A because of said action. I didn't get hearing aids. I didn't get a change in position, and I asked more than twice or three times since 2009. I didn't receive proper medical treatment, or I was denied. I haven't been paid. I should be working. I haven't been paid since December 7, 2010. And they stripped me of my lifetime medical and the other medical, which I'm glad to have. They took me off the job. They took me off the job illegally, and I should be working. So I filed this 132A dated February 11, 2011. It was submitted by Adam Stewart because they're in violation. And I'm asking that the applicant be reimbursed for lost wages, prejudgment interest, and all other compensation under the provisions of the Labor Code Section 132A and be reinstated to my job. Because I'm still working there, but I'm not working there. They haven't called me back to work. I'm on standby because they didn't let me log out of the truck or let me clock out of the truck, in which there is no time card, and I don't get paid by that time clock. They have two time clocks. One's a log for the automatic onboard recording device, and the other one is a time clock with no time card, and you don't get paid by that clock because there's no way to show or prove that you even work after you log out of the tractor automatic onboard recording device, which puts you on duty at 10:30 in the morning every day you come to work. As soon as you hit that property or contract, you're on duty. When that guard signs you in on Safeway Tracy Distribution Center, you are on duty before you even get to the dispatch office. Once that guard signs you in, you are on duty. But they require you to use the time clock to clock in. Why, I don't know, when you're already on duty. I don't know. So anyway, I filed the 132A on, again, dated February 11, 2011. That's my statement for the court, and I'm asking to enforce the 132A that I be returned immediately and that I be paid the compensation of $1,000+ every week that I've been. Because the fact is, offer work states that I had a chance to respond in 20 days because they sent me home. So automatically they have to work me, and they didn't do so. They violated 132A. That's my statement for the court. Today is Thursday, September 27, 2010. And I should like to note one thing. I'd like to note that you got to remember in the back of your mind that I have an onboard recording device in the tractor, and that's what I get paid by my laws. Okay? And I'm under DOT regulation 14 hours on and 10 hours off. And the second time clock in the driver's room does not have a time clock. It doesn't show anything. You don't get paid by that time clock. And it doesn't record the miles. It doesn't record anything after you log out of that tractor on the onboard recording device that we one thing. The unemployment office said it was a conflict of interest. Conflict of interest. They had no right to decide anything. And I also like to note that since 2002 ongoing, I've never been paid for any breaks, lunch, or rest periods. Nothing. They've never paid me nothing. And I was working 16 hours a day. And then they changed it to 14 hours a day. But in reality, we were working more than that because we had to clock out on the company time clock, which has no time card, and they don't pay you by that clock. It doesn't record anything. It doesn't show the difference in miles. It doesn't show anything, okay? It's no time card. So I'm asking for the consideration for the court to put me back to work immediately. Why? Because justice delayed is justice denied.
Mr. Sadler says, this is your day off, and then I go, yeah. He says, you want to work? You know you're not supposed to work on your day off. Well, I ain't going to argue with this man. Okay, I don't want to commit insubordination. I don't know what he'll do. I mean, because he wrote me up one time because I went to sleep on the side of the road. I was so tired. I couldn't drive straight. So when I got in, he said, you could have made it in on time if you hadn't stopped, right? I go, yeah. And he wrote me up. Okay, well, that's fine. This has been going on until the whole thing of 2009. Just constantly. Being harassed, yelled at, accused, name-calling, on medical leave, not authorized, not being paid, just career harassment. Okay, so back to the letter with Dr. Hubby. It says, thank you for your request dated 4/8/2009. 4/8, I just got out of the hospital in 4/6 for a referral to a neurosurgeon for the employee's low back. Imagine that, because that's what the hospital said. We respectfully object to your request at this time as the accepted body parts for the above caption. Claim is left thigh and left knee. It is noted that when you initially evaluated Mr. Zamora, he was not suffering any symptoms to his low back. Well, she didn't evaluate me. It was Nancy Perdino that evaluated me because she was the first one that saw me. And Dr. Hubby, all she did was a follow-up and sent me home because Nancy's the one that did it by phone. So I don't know why they deny it, but it says, please advise your opinion if the employer's current system is to his low back are related to the injury of 3/21/09. Did the employee suffer any new injuries either or industrial or non-industrial basis? Well, I don't know what to say about this letter, but I don't know how to say it. Okay, I'm not going to say it. I'm going to let the judge do it. Okay? And then we have May 20th, 2009, termination of disability benefits. Okay, now they say I owe them money. And this is per Dr. Patel's report. Payments are ending because you were released to return to work on 4/17/2009 by Dr. Patel PR2 report dated 4/17/2009. Your condition is not industrial and you were referred to your primary care physician. Okay, I was referred to my primary care physician. Isn't that something? That must be Mr. Perlosi. Okay, so on that date I went and hired an attorney, Adam Stewart, on 4/17. Okay, 4/17, I hired an attorney. Okay, I got a letter here. It was mailed on 6/16, but it was claim effective 4/17. It says notice of conflicting liability. And it also states it's against the law for them to decide or make any decisions whatsoever. So they're a violation of state law, labor law. Okay, so that's fine. At least I got unemployment insurance while I was off because they never paid me 1 cent other than for the 3 weeks or 2 weeks that I was on disability, whatever it was. I don't know. I don't remember. Okay. On 4/13/2009, I filed a claim with Workmen's Comp to be paid each day work work caused by refrigeration unit noise. That's a trailer. I haul frozen and produce. I have hearing impairment since 2008. I have a DOT physical every 2 years. So for them to say they don't know anything about it, or the union, Mr. Neiswanger, who all of a sudden says, well, that's the first I heard of that. Well, I beg your pardon, I have a witness, and I have a document here dated 10/2/2009, okay, sent to you, stating I have a hearing impairment. On top of that, we had a hearing that day, and the internal manager, Fry, was there, okay, and we had to hear a discharge case or whatever it was, because I asked him, if you think I'm lying, fire me. Well, I know I shouldn't have said that, but I said it, because the guy was just, boy, he was just something else. And then he turned around, and he fired me the following week, and then he had to take it back. And on top of that, he put me on medical leave, unauthorized medical leave. I had a full release to go back to work at the union, agreed with the terminal manager. Agreed with the terminal manager, full duty release. And they put me on medical leave. Imagine that. And no pay. When I got off of that, I never got no pay. I never got nothing. Zero. Stitch. And it's fact. In 2009, they only paid, Jesus Christ, they didn't pay anything on my pension or on my RSVP, because I got the sheet right here. They didn't pay anything, 2009, on my pension or my RSVP, even though I only had 1 month to go, and I paid for it myself out of my pocket, which makes me qualified me for retirement. And I got the document right here, and it's dated, statement was dated March 31st, 2009. Reflects contributions through February 28, 2009. It says first RFP was 2003. Minimum requirement contribution 60. Total accumulated 59. Required to meet minimum was 1 month. Earliest possible RSP enrollment date for retirement was March 2009. 2009, okay? I was eligible to be retired with lifetime medical insurance. Okay? And I should also note that in 2009, when they had me off for 10-2 illegally, and then when they got around to putting me back to work, they never paid me 1 penny back. And didn't pay my pension or anything else, and the union agreed. And on top of the meeting that I had on January 11th, 2011, we put the meeting in abyss, and he wanted to know why I didn't say anything. I said, well, I didn't hear anything. I don't understand anything. You need to accommodate with some kind of listening device, which they never did since 2008. No place, no time, anywhere. And the panel at the abyss, he says, well, if you need a hearing aid, we'll make sure you get one. I'm going to say that again. If you need a hearing aid, or you need to be accommodated one, well, we'll get you one. Okay? Because we want to know why you didn't say nothing. And I told him I didn't hear a thing. I didn't understand anything. But I was looking at what they were accepting. And they were accepting documents that shouldn't have been accepted because it didn't tell the whole truth and nothing but the truth. And on top of that, I mentioned to him on the 10th of January 2011 about that you need a DOT official in there to explain to them what the regulation is. Because if anybody changes your time on your laws at any time without my permission, it's against the law. But they didn't do that. And not one time, any place, anywhere. Not even the attorney that I have for workman's comp. They convinced him, and I've got the letter. Oh, it appears that I changed the starting time with my own hands. My own hands. I got the letter. Now, how am I supposed to be defended at workman's comp with an attorney that agrees with the insurance company and sends me a letter stating you're guilty? Okay? Now, I'll give you one better than that. Even the union attorney agreed with Mr. Neiswanger because he had a discussion with Mr. Neiswanger, and they said they could prove it beyond a reasonable doubt without a DOT official that's an authority on Department of Transportation regulation, which I'm under 14 hours a day. With no official at any meeting, any place, any time. And they weren't asked for their advice, and I never seen a letter or any such thing stating that I falsified anything or intended to falsify anything. There's not one document. And they never booked anything on December 5th when they were required to do so. They didn't do it, according to the contract. I'll give you one better than that. On step 1 in the contract, it says if you don't respond within 10 days, okay, then the case or discharge, whatever it may be, is null and void, final and binding. You don't need to go any further than that. Okay, and it was declined because Mr. Nightwanger sent them a response on December 17th. They filed a grievance on December 17th or 16th, but it was received by Local 439, stamped received on December 17th for the actions or discharge on December 6th, which is more than 10 days. And then Mr. Nightwanger said, you need to prove your case and you need to send everything you got by December 25th. And set a date and time for the hearing to discuss what you've presented, to see if I'm guilty or not guilty. Well, they never responded. They never proved anything. Nothing. In fact, they set a meeting date for January 11th, 2011. And then all this was emailed. And on the bottom of the letter of the grievance filing, it said down below on the left-hand side, they sent it to labor management, this person, that person, and on the top it said reference Julio Zamora, and down below where they send it to everybody, it says employee. Now, they had 30 days to send me a registered mail because they have to notify the grievance by registered mail. They didn't do so. So there is no discharge, there isn't anything. And the legitimacy of this panel hearing is in question. Because the attorney denied me arbitration knowing the fact that they violated step 1. And it didn't have to go any further. Okay? So I'm saying I have a severe, profound hearing impairment, and the fact that they didn't accommodate me with a hearing device and said, Mr. Nightwanger said that he would if I needed one, and never did it and went into caucus and sent me home, proves my point. Was I treated indifferent? Well, of course I was treated indifferent. For the last 10 years I worked there, all the shop stewards, when you get a letter and it doesn't comply with the contract within 10 days, they don't sign the letter, nothing happens. The employee is returned to work immediately with all back pay and benefits. Well, on December 7th, I was sent home. And I had an FMLA, like I said before, and they took everything away from me. And I had an offer of work good for 1 year. I had 20 days to decide. They didn't do that either. I didn't get the 20 days, even though I had the paper in my trunk. And on top of that, I don't know who signed it. But I had an offer of work, agreement by Workmen's Comp and Safeway. They didn't honor it, and nobody told me why I was sent home. I didn't find out till later at the end of part of December that they tried to send me a discharge letter, which I never received. On December 17th, they emailed it to Mr. Nightwanger, and he replied, denied. But yet they continued on. Okay? That's in violation of the contract. What are they doing? They didn't honor the step 1 on the contract, Article 25 and 26. And the union attorney is just right along with it. If it's not discrimination, I don't know what it is. On 10-2, I had a full duty release. Nightwanger didn't do nothing about it. He didn't even give me my back pay. In fact, when you're discharged or anything else, you're supposed to go to Board of Adjustments. On suspension and discharges once a month. Well, I never seen it. I don't think I've ever seen a Board of Adjustment as much as they've been harassing me and not paying my medical bills and not treating me right, just treating me indifferent. Okay? And now I got these letters here with peculiar dates and times and signatures that don't match up, and one of them under oath says that that they're an employee of the state, and they're no way involved, but yet they signed this document, offer of work, which means that they're involved. So anyway, and I'd like to know one thing. I went to see Thomas B. Byron, M.D., from neurology for my pinched nerve. He gave me so much medication. He told me I'm in a serious health condition and that I need a spinal shot. Well, I don't want the spinal shot. I didn't go back because I didn't get the operation, and I had to use my own Medicare insurance or Medi-Cal, which they didn't pay them. They owe Medi-Cal, they owe the insurance company, and the treating physician, I don't know. I heard they paid them, but I don't know. But he won't let me go back there and get treated. He won't accept me unless I pay cash. And he's supposed to be my treating physician. Now I have to go to Dr. Yip, and I asked for that. I never got approval yet. Okay, I got a letter today, but I'm going to call Dr. Yip tomorrow and see if it's true. So that's that. So now we're going to go on. Now we know that the signatures aren't matching and that the dates are all wrong. I don't know how they knew I was hurt before start my disability before I got hurt. Now, I'm not going to say anything. I'll let the judge come to his own conclusions. Okay? And now we'll get into Dr. Patel here. Okay, I got 308. Oh, yeah, I got this thing here on 32109. It says injury left leg 4809, health and safety room. This was signed by Michelle Ortiz, signed by me, and I guess there's Michelle Ortiz signed twice. On 4809, they put me on light duty. I just got out of the hospital on 46. On 46, I just got out of the hospital. And they put me on light duty. I'm on Vatican and everything else. Okay, that's for the record. Okay? And because you have to be back on light duty within 30 days. That's their policy. So, I got an MRI that I turned into Dr. Hubby. I turned in the doctor's first report of occupational injury. And I guess I'm going to have to present it because I don't know I don't know how my attorney's going to defend me because of the letter that he received, and he questioned me about it and making saying, well, you got to prove yourself and everything else that you're the one to change the time and all this other stuff. And the guy won't talk to me. He says, don't send me any more documents and this and that. He's not listening. He's not listening. When I go to court, I can't get to a judge. I had a settlement conference to go see an administrative judge, and Mr. Stewart and the junior attorney went in there before me and my wife went in there. And he asked me some questions, I responded, and he says, leave the room. Leave the room, he says. He said, please. He said, please leave the room. He's a very nice man, very soft-spoken. So I left the room. Maybe 5 minutes later, Adam Stewart comes up and says, how long can you work for? How long can I work for? I got an offer of work for 1 year. I tried to hand it in on December 7th, and they sent me home. And now you're asking me how long I could work for? And then he walked away and the other attorneys with Safeway. On the phone. You know what they did? They sent me to the lunchroom, and then later they told me to go home. It's taken off calendar. What? You know why? If the administrative judge said put this man back to work, or made a suggestion to do so, isn't it correct that they should do it? Am I wrong about this? Am I wrong about the dates that I have that don't match? Putting me on disability before I got hurt? Or starting my disability? And Dr. Patel here stating that I had a PR2 at 12 o'clock in the morning when I was home in bed with my wife? And then another one on the same date? Okay? Dr. Patel, I was there at, 1:15? And who did I see that day? I got the report right here. I'm not making this up. This is for real. And Dr. Patel made a report. I don't know if he's the one that examined me, but I have the document here. He signed it. He said, I think this is a non-industrial injury. He said he wasn't sure. That's what he says on the document. And then I called Maria up. On the 17th, I called her up. and I had a speakerphone on, and people were here. And I said, Maria, am I still on disability? She says, yes. Not more than an hour later, this guy calls up and starts, I don't know what he's saying. The guy knows I have a severe, profound hearing impairment. I've been filing every 2 years. They all know it. But they're not going to admit it, just like he didn't at the panel hearing when he put it in Abyss. Okay, and then they went into caucus, and I don't know what happened. They never told me nothing. But it should have went to the border. It should have went anywhere. Okay, but anyway, Dr. Patel, I don't know what he says. I'm not sure. And then Esperanza goes and says, well, I'm terminating you. I read you that letter, what she said, because Dr. Patel said it's non-industrial. Well, that's not what the statement says. And there's a question here, like, you know, on 4/17, I was in Tracy at 1:37 p.m. And I left around 2:35. And now he makes that a PR2 report, okay? And somebody needs to, I got to tell you, hey, I wasn't there at 12 o'clock in the morning. I don't know how he got all my vital signs and all this other stuff, and he's saying that I signed this, and you know what, I don't know what he's talking about. He can bring out any document he wants to say that I signed it. The fact remains, when I talked to Maria, I was still on disability, but yet they terminated me. That's discrimination. They had no right doing so because he said I was not sure. Esperanza terminated me by a PR2 report. There's something fishy going on here. You got a work status report, and now you got a PR2 report that's made out at 12 o'clock in the morning when I was home in bed. So I don't know what's going on. You got a lot of things here that are all screwed up, and the union is also discriminating against me. For accommodations, agreeing with the company, not applying me a listening device when he said he would. The union attorney agreed with Mr. Neiswanger and denied me arbitration. There was no DOT officer to testify at any time, any place, anywhere to back up their story. And I have a document here that says attention Neiswanger, FMLA. I have it right here. Driver Safeway, attention, Robert Neiswanger, December 13, 2010. Well, he must have knew it before then because terminal manager Fry got the same letter, and it's his file. So if he didn't tell everybody, that's not my fault, okay? And it was good for 10/13/10 through 10/12/2011. And there's something going on here. I don't know what is going on, but they're saying by word of mouth, because they didn't put anything on December 25th. They're saying by word of mouth that I'm guilty, that I did this and did that, but yet they didn't prove it on December 25th. So they convinced everybody that I falsified. It says intent to falsify, but they're saying that I falsified when in fact the dispatcher did, the one who made out the report on December 7th, 2010. Okay, and I have a director of Department of Transportation, by his own words, says that it's against the law for him to do so. He broke the law without my permission. He broke the law.
And there's no doubt about it. The dispatcher changed my logs on December 6th. He took the time from the dispatch office, which we don't have a time card, and he changed the time on my logs on the onboard automatic recording device 395.15 and the interpretation. You can verify it by looking up 395.15. The dispatcher intentionally falsified my logs on the onboard automatic recording device in my tractor. Okay, and to end this tape, I'm going to say we don't have a time card and we don't get paid by that time clock. And for the last time, I'm going to state that when we come into the guard check, when we report for work, we're on duty. When that guard signs us in at the guard check, we are on duty. On duty. We're to report to dispatch. That's how it goes. It's how it's been since 2002 August. Okay? You sign it to guard check, he signs you in, you're on duty, you're to report to the dispatcher. Why they have a time clock? They require us to punch in when there's no time card, and we don't get paid the difference. We don't get paid the difference in miles. We don't get paid anything, nothing, zero, six. There's no time card to show that you were even there. Okay? So there's nothing that you can look at in your hand with a time card to see what time you punched in or punched out, or if you're even getting paid. You get paid by the onboard automatic recording device in the tractor, and no one's allowed to change that time. Okay, without your permission. And furthermore, you have to have a key. The supervisor is the only one with a key that could possibly do that. So that's the end of tape. End of story.